First of all, can I add my thanks to all of you for coming, because these events are great fun. We really enjoy doing them, but they only work because you come and you bring your energy to it. So thank you very much. And welcome to all of you. There's lots of lovely familiar faces here, so it's great to see you. But for those I don't yet know and who don't yet know me, I'd like to introduce myself. I'm Lydia Banerjee, and I'm joined by my colleague Charlene Ashiru. And we're going to very briefly take a look at some issues that arise when we're looking at time limits in discrimination claims. So we are going to look at, in particular, when does time start to run, continuing acts, just and equitable extensions, as well as when is it best to deal with any points around time limits. So before I look at some specific issues that come up when we're considering when time starts to run, I think it's just helpful to anchor ourselves very firmly in the statutory provisions. And of course, this is the lovely section 123, my favourite one, because it's just the easiest number to remember. And this is where we get the rule, which we'll all be familiar with. There are some seats here if you want, sorry. I can do that to Natasha because I know her well. Sorry, Natasha, come and grab a seat. And 123 tells us that we've got 3 months from the date of the act complained of. It also says all such other period as the employment tribunal thinks just and equitable. And as I've already alluded to, and if anyone wants to sneak ahead in the slides, they will see we're going to cover just and equitable in the second half, and Charlene's going to cover that. So on the face of it, from the moment that the act takes place, is quite an easy one to understand. There's a couple of points I just wanted to highlight in relation to it, just to make sure we stay aware of them. The first is that the individual does not need to know even that the act has taken place, and they don't need to know that it amounts to discrimination for time to start to run. That might seem a little bit odd, but as it was explained by Murray in the Mensa case that you have on the slides, knowledge is a factor relevant to the discretion to extend time. It is not a precondition of the commission of an act, which can be relied on as an act of discrimination. So our time starts to run from the point at which the act of discrimination is complete, which does not require the individual to be aware of it. However, it's plainly going to be relevant to the question of just and equitable extension. Why am I flagging that at this point? We're going to hear about just and equitable shortly. The reason I'm flagging it is because it can be tempting from an individual who realises, wait a minute, I now know the person appointed doesn't have my protected characteristic, I now believe there to be discrimination, to think at that point their 3 months starts to run. But it doesn't. Their 3 months is already running and may have already expired. So it's important that they don't act on the basis of having 3 months, take their time about it, dawdle along with it. They're going to need to demonstrate that it's just and equitable to extend time, so they're going to need to act promptly from the point of knowledge. So that's why it's important that people are aware of it. And the second point that I wanted to cover in relation to when does time start to run is around termination and dismissals. Now, we'll all be familiar with the idea that we've got 3 months from the date of termination to bring a claim in relation to a dismissal. But the challenge can arise where, and this will be quite familiar fact pattern for many of us, there's a series of events which are said to be discriminatory in one way or another, culminating in a decision to dismiss. Now, if that decision is immediate termination, we don't really have an issue. But if, as can happen, we've got termination on notice, perhaps a period of garden leave, in which that person is out of the business, nothing further happens, there's no additional discrimination, then we can find ourselves in quite a difficult position. If we wait until the date of termination and start our 3-month clock and bring our claim, those acts of discrimination up to and including the decision to dismiss could well be out of time. And so if we have a situation where someone is on garden leave, we need to be very alive to the fact that actually, unless there's a further act to continue it, and we'll look at continuing acts in a moment, we could get ourselves awkwardly in a position where the bits where the real value of the claim are in terms of taking away that cap become out of time if we don't act promptly. And the third point we're going to cover is, of course, continuing acts. I'm going to cover it over the next few slides, but I thought before I do that, it's just helpful to, again, have that wording in front of us. And that's just 1, 2, 3, 3. And 3A says that conduct extending over a period is to be treated as done at the end of the period. Now, continuing acts are always what we rely on when we're dealing with discrimination and time limits. But actually, what are we thinking about and what are the key issues we need to bear in mind? So, first of all, we've got a distinction between a continuing act and a one-off act with continuing consequences. That's something we'll all remember from our first days of studying employment law. Just to remind ourselves of what we mean by that. A continuing act will be something which actually has a pattern or a policy or a regime, or there's a fact pattern around it. And that is contrasted in this situation with situations where we make a decision, let's say not to promote somebody, not to award a pay rise, make a grading decision in relation to their role. And that has continuing consequences for them in terms of their pay or the level at which they're remunerated or the benefits they have access to. But actually the decision itself is a one-off. Now, the one-off decisions, time starts to run from the decision, despite the fact it continues to have an impact on that individual on an ongoing basis. If that decision is repeated, so for example, if we've got a pattern where pay determinations or bonus determinations are influenced by discriminatory factors, and that's happening on a quarterly or annual basis, then we may be able to establish that continuing act. But if it is literally a one-off decision as to who is going to be appointed to a role, then the fact that that appointment continues is not going to help us. What we're generally looking at is a situation where we can put lots of different bits together to demonstrate that it's not just an isolated incident, but there's actually more to it. And one of the ways in which we can do that is to look towards a policy or a practice which the business implements, which has a discriminatory effect. But even with that, we have to be very careful, because a policy may be discriminatory. For example, a registration requirement that in some way favours people who have UK qualifications. But the actual application of that policy to an individual may still be a one-off. So when that individual applies to register and they experience that discrimination, for that individual, that is still a one-off decision. And so even with a policy or a discriminatory regime in that sense, we still have to be careful as to whether there is ongoing discrimination for the individual or one-off. And Chowdhury, which is one of the cases you've got on the slides, is an example of that. Now, Hendricks is probably the case that most of us think of when we think of continuing acts, and it'll be familiar to many of you in the room. This was the individual who was a black female police officer, and she brought complaints of sex and race discrimination. And there were, in that case, I think there were around about 100 allegations of discrimination, and there are around about 50 different people who were said to be involved with the acts of discrimination. And the wording that comes out of that case, which will be familiar to all of us, is that what was established, or what they were looking at, is where there was a continuing state of discriminatory affair. And that might arise from lots of different acts and omissions that are linked in some way. It might arise when we've got the same individuals who are perpetrating it. And we'll look in just a moment at other factors that might help us to establish continuing act. But before we do that, I just wanted to highlight something from the Allen case, which I think is the last one on the slide behind me. And that's about whether or not we can rely on things which would not have happened but for the discrimination. So we've got a discriminatory act. If we hadn't had that discriminatory act, this later unfair thing would not have happened. If that unfair thing is not in itself discriminatory, then we cannot rely on it as part of a discriminatory continuing act. And so that's quite important, because sometimes people will say, well, I was discriminated against here, and as a result of that, this happened and that happened and that happened. Unless those things are themselves in some way connected to discrimination, then we can't rely on those as forming a continuing act. So what can we look at when we're looking at establishing whether or not there is a continuing act? Well, we're going to look at the nature of the conduct, and the central part of that will probably be looking at the reason for it. And that might be fairly obvious in some situations, and it might be more difficult in others. So, for example, let's say someone's given a discriminatory nickname. Well, every time that nickname's used, we can rely on that as being part of a continuing act, a continuing discriminatory state of affairs in which that person is operating, and the time will start to run from the last time in which that's used. That's not a particularly difficult scenario. The much more difficult scenarios and the much more common scenarios that we find ourselves dealing with are where we've got a lot of different things which are not necessarily done by the same person, they're not necessarily done close together, and yet our client is telling us when we're acting for the claimant, this is all because of. And then we're looking to see, is there a common reason behind it? Can we see a causal link behind it? Is there some kind of attitude or regime that we can establish within the business, perhaps from some wider evidence, such as staff surveys and things which demonstrate there is a general sense that people with a particular protected characteristic are disadvantaged? Is the conduct repeated? It doesn't have to be, on a consistent time every week. It can be a mixture of different things. It can be happened here and then it happened 2 months later and then it happened 3 months later. But is there a repetition of it to suggest this was not one-off or isolated? And it doesn't have to be the same, exactly the same conduct, but we're looking for something about the nature of the conduct which makes it look connected. There are certain things, like processes, which we look at and can say, well, inherently that is something which is part of a continuing act. So, for example, if we instigate disciplinary and go through the disciplinary process and it culminates in a decision, inherently that is all part of one process rather than being a series of isolated events. But that might not be linked to a separate process that takes place 6 months later. So we need to bear in mind that just because we've got pockets which can be grouped together, we then still need to form the link between that and the later event if we're trying to rely on it. And one of the things that we're going to spend quite a lot of time looking at probably when we're considering these cases, whichever side we're representing, is the individuals who are said to be involved. Very often these arguments will turn on, well, this person didn't like the fact that I am female, and I think that although this decision was made by somebody else, they were really doing it because they were influenced by that person's discriminatory attitude. And so often we're looking at kind of a web of influence. Now, if the allegation is that the person who held that discriminatory attitude is actually relatively junior in the food chain, it's going to be difficult to establish that people who are much further up the hierarchy were influenced by or persuaded to act in a way which was influenced by their own discriminatory attitude. If, on the other hand, we've got leadership who are setting an example and we can evidence actually that discriminatory attitude from them, it's much easier to say that their direct subordinates, those within their sphere of influence, are likely to be either encouraged or influenced by a desire to please them, which may in fact link those discriminatory acts. And obviously, the other factor is the number of individuals that we're looking at. And sometimes it's very difficult when we've got allegations, and this happens quite often, especially when there's been an extended period of time of unsettled conduct in the workplace, where when you actually add it up and you look at all the different acts of alleged discrimination and you work out who actually made each of those decisions, and then you look at the list of people who you're accusing of discriminating against somebody because of their race or their gender or their sexual orientation, etc., you can end up with a list of 20 plus people. And that's actually quite an uncomfortable position for an employment tribunal to be in, because the idea that there would be 20 plus people in an organisation who've all acted to somebody's detriment because of, if we're looking at direct discrimination, a protected characteristic, is quite a significant finding for them to make. And so one of the things that, if you're on a claimant side to look at, is actually which of these allegations adds to the claim in terms of value or in terms of persuasiveness, which of these are needed for establishing my continuing act, and maybe I don't want to bring every single claim because putting it all together might actually be undermining the strength of the bits which would establish the same value of output. And on a respondent side, of course, you'll want to be saying, so this is another person that you've accused of, discriminating against you because of, so you're saying that they're racist or whatever it might be in terms of the protected characteristic. And you can see how the number of people involved can really influence how that's viewed. So I've just got two short points to cover before I hand over to Charlene. The first is, what about different types of prohibited conduct or different protected characteristics? Can we use those together to demonstrate a continuing act? And it's easy in relation to prohibited conduct. So if you've got harassment, indirect, direct, victimisation, yes, you can use all of those different types to establish a continuing act. It's a bit more complicated when we look at protected characteristics, but it's not impossible. And the quotation from Alan reads as follows: I cannot see any reason why conduct extending over a period cannot involve a number of different types of prohibited conduct, such as harassment and direct discrimination. That's the point we just covered. It may be more difficult to establish that there has been discriminatory conduct extending over a period, where the acts that are said to be linked relate to different protected characteristics and different types of prohibited conduct. But there's no absolute bar that prohibits there being conduct extending over a period in such circumstances. End quote, just so you don't think the next bit's also part of the quote. What's important to note, though, is that it's got to be a single course of conduct and not two different streams of discriminatory behaviour. So there would need to be some sort of demonstration that the two are in fact linked. And the final point, just to pick up, because it arose in a case that Charlene was involved in, and we thought it was an interesting one raised by the judge, is whether you can combine acts which are said to be discrimination with acts that are said to be detriment for whistleblowing when you're trying to establish your continuing act. And the judge in that case, not deciding it, was just at a preliminary stage, indicated that they thought it would be possible. And that caused us both a bit of head scratching, because it's not immediately clear that when you're looking at time limits under two different statutory regimes, it would be possible to link the two. I'm thinking about it in preparation for this talk. I could see that if the whistleblowing was potentially linked to an act which might also be, say, a protected act, then it might be possible, but then really question whether that was adding anything to looking at it just purely on the discrimination allegations. But it is something which obviously at least one judge has considered might be possible, and so it's something you might want to consider if you've got a whistleblowing and discrimination claim combined. So on that note, I'll hand over to Charlene to look at the just and equitable test.
Thank you. So I can see you all looking at me thinking, just an equitable test. I know everything I need to know. It's a broad discretion. What can they tell me that I don't already know? Well, the reason we raise this is because it's all too often forgotten to deal with the just and equitable test in evidence. So if you're acting for a claimant, often the witness statement doesn't include evidence about the reason for the delay, especially if it's being dealt with at the final hearing. If you're acting for the respondent, often the instructions or the evidence doesn't deal with potentially forensic prejudice. So I raise this as something more of a reminder, and in terms of giving you practical tips on how to best represent your client's interests in those scenarios. So as Lydia has already explained, the just and equitable test only applies to claims under the Equality Act. And as Caston, as cited on the slide, makes clear, the question is whether there is material upon which the tribunal can properly exercise their discretion. Now, in terms of the burden in establishing a just and equitable extension, it's a burden of persuasion. It's not a burden of proof per se, but the burden is on the claimant to persuade the tribunal to exercise its discretion to extend time. Now, in Caston, the Court of Appeal said limitation is not that large. There are statutory time limits which will shut out an otherwise valid claim unless the claimant can displace those time limits. Now, we're probably all aware and often cited the Court of Appeal decision in Robertson and Bexley, where the Court of Appeal said a tribunal cannot hear a complaint unless the applicant convinces it that it is just and equitable to extend time, so the exercise of the discretion is the exception rather than the rule. Now, that is not the same as saying that there is a requirement for exceptional circumstances. There is no requirement for exceptional circumstances, but there does have to be some explanation for the delay. And of course, the balance of prejudice will always be key. Now, in the recent case of Jones and Secretary for Health and Social Care cited on the slide, His Honour Judge Taylor warned that comments in Robertson have to be viewed in context, namely that employment tribunals have a wide discretion to extend time and just and equitable grounds, and that appellate courts should be slow to interfere. He said tribunals should focus less on the comments in Robertson, that time limits are applied strictly, and more on the Court of Appeal authorities in relation to the broad discretion at play, such as Abatorwi and Morgan, Afolabi and Banerjee. Now, I apologise for my pronunciation, not the easiest cases to pronounce, but they're all on the slide, so I defer to your pronunciation of those cases. Now, in Morgan, the Court of Appeal emphasised the broad discretion, and in reference to Afolabi, went on to say that the only requirement is that the tribunal does not leave a significant factor out of account. So what does that mean in practice? It means that the tribunal needs to look at all the circumstances. In Banerjee, the Court of Appeal said that the tribunal must assess all the factors in the particular case, which it considers relevant to the exercise of the exercise of the test. Now, the tribunal may find the checklist factors in Section 33 of the Limitation Act helpful, but it's not a requirement, and the tribunal will not err in law if it doesn't refer to them, but often everyone refers to them anyway, just to make sure they've ticked off that box. Now, in the Morgan case, the Court of Appeal made it clear that there are essentially two key factors which must always be considered. Firstly, the length of and reasons for the delay, and the balance of prejudice. So, for example, if the respondent has been prohibited from investigating matters whilst the allegations are still fresh, obviously that's quite a weighty factor in respect of the balance of prejudice. So the first factor then, the length and reasons for the delay. Now, there were previously conflicting authorities at EAT level about this, as to whether it was a determinative factor or not. That has been settled by the Court of Appeal in the Morgan case, which held that there is no requirement that the tribunal must be satisfied that there is a good reason, or indeed any reason, for the delay, but it is a relevant matter which the tribunal should have regard to. And again, it's one factor in the mix, it's not a determinative factor. Nevertheless, the absence of a good reason for the delay is likely to weigh heavily in the balance of whether or not it would be just and equitable to extend time. Now, in the Owen and Network Rail case cited on the slide, the Employment Appeal Tribunal found that the tribunal had not erred in law in saying that the claimant must give some explanation. And the EAT highlighted, and this is important, the EAT said it's not sufficient for a representative to give reasons in submissions, or indeed could be said in correspondence, because that is not evidence. While a submission may highlight evidence that's relied upon by the party, need not be witness evidence, but the submission still has to rely upon some feature of the evidence. So there could be contemporaneous documentary evidence, it could be witness evidence, but a submission alone in correspondence or in a skeleton argument isn't sufficient. However, the Employment Appeal Tribunal in that case found that the tribunal did err in suggesting that the absence of any evidence for the reason for the delay tied its hands, and it was bound to refuse time as a result. Again, it reiterated it's a relevant factor, it's not a determinative one. So I've listed on the slide some examples of how this arises in practice. The first one there, internal processes. Now, this is something that often comes up, and the key issue here will be whether that has caused prejudice as a result of the lateness. Now, as I mentioned before, if the allegation was made at a time when the matters were fresh, such that the employer had a chance to investigate them, then that's a key factor pointing in favour of an extension. Another one, fault of legal advisors. We see that come up in both under the not reasonably practicable test and under the just and equitable test. It's stricter under the not reasonably practicable test. There's more scope to extend time where the advisors are at fault under the just and equitable test, because the tribunals tend to find that the fault shouldn't lie at the claimant's door. So that may well be another factor pointing in favour of an extension, of course weighing up all of the factors. Another example is mistake or ignorance. Again, often you find litigants in person relying on this factor. Now, most people are expected to be aware of their rights under the Equality Act, which are now very well publicised, especially in recent times. And the claimants are expected to have taken reasonable steps to either research their rights or take legal advice. Ignorance is slightly different, and Lydia mentioned this at the beginning. They may not be aware of the facts giving rise to their claim. Obviously, that will be a relevant factor, but the ignorance must be genuine and it must be reasonable. Again, that will require witness evidence, and that evidence will no doubt be tested in cross-examination. Ill health or disability, again, likely to be another weighty factor. Again, will require medical evidence, especially in relation to the end of the limitation period. So just some examples of the types of reasons we see coming up in tribunals for delay. Turning then to the prejudice of the parties. Now, when considering prejudice, in Miller, Mrs. Justice Lang, as she then was, noted that there are two types of prejudice a respondent may suffer if limitation is extended. The first is the obvious prejudice associated with facing an otherwise time-barred claim and the cost and hassle of dealing with that. The second is forensic prejudice in terms of the cogency of the evidence, losing touch with witnesses, not being able to investigate while matters are fresh. Now, the former type of prejudice will arise in every case. Extending time will always oblige a respondent to go to the time and effort and expense of defending a claim that is otherwise time barred, and of course exposed to the risk of losing, whereas not extending time will always deprive a claimant of having their complaint adjudicated upon. Now, those two are likely to cancel each other out to some degree. However, forensic prejudice will be more key in these circumstances for a respondent, and Mrs. Justice Lang said that this type of forensic prejudice is crucially relevant and may well be decisive against an extension. On the flip side, however, if there is no forensic prejudice to the respondent, that doesn't necessarily mean that time will be extended. Again, it's just another relevant factor. So, practical tips if you're acting for a claimant who is either in need of a just and equitable extension or is relying, and more importantly, relying on a continuing act with the final act being in time. But of course, there's a risk that that final act is not found to be discriminatory and all the earlier acts are out of time. Make sure you've got some evidence as to the reasons for the delay, either in the contemporaneous documentary evidence or in witness evidence. Don't leave that as something that is forgotten about in the midst of all the other evidence, especially if you're dealing with time limits at a final hearing, which is quite easily done when you've got hundreds of allegations that you need to address in witness statements. Make sure you've got a section on just and equitable extension as well. If you're acting for the respondent, take instructions on and make sure you lead evidence as to any forensic prejudice you have in your case. So, for example, if witnesses have long left the business, if they're no longer contactable, if you haven't been able to investigate the matters whilst fresh, so you don't have that collation of evidence at the relevant time. These are all points on which you should, as a respondent, be leading evidence on. Finally, then, the merits of the case. I just want to deal with this very quickly, given the time, but merits of the case can be relevant, provided they are dealt with appropriately. If a time limit issue is being dealt with at a preliminary hearing, then, of course, consideration of merits is speculative. Kumari stands as authority that it can be considered as long as it's done appropriately, but tribunals often tend to be cautious and say, well, I can't assess the merits because I haven't heard the evidence. However, if time limits are being dealt with at a final hearing, it's no longer speculative. The tribunal's heard all of the evidence and is in a position to make a determination on the merits. And in the Bauhaus case, which I've listed on the slide, it was said that the balance of prejudice is all one way. It impacts solely against the claimant's interests. So there's no prejudice to the respondent because they've already defended the claim. So a respondent is going to need some very persuasive reasoning to convince the tribunal not to extend time where a claim is made out on the merits. This brings me finally then and very quickly to when to deal with time limits. Obviously, if you're dealing with a not reasonably practicable test, you'll almost always want to deal with that at a preliminary hearing because it's a strict test and it's a knockout point. It's not so clear-cut with discrimination claims, especially if one of the acts in a continuing act or alleged continuing act is in time, because tribunals tend to say, well, we'll deal with it at the final hearing. Bad news for the respondent, good news for the claimant. But I do encourage you all to read paragraph 50 of the EAT decision in E and X, which is cited on the slide, because that gives some useful guidance as to when time limits can be addressed at a preliminary hearing. The upshot is that it can be done, provided that it's done in appropriate cases and cautiously. Now, if all the claims are out of time and you're just looking at just an equitable extension and not a continuing act, that is a strategic decision depending on the facts, bearing in mind the Bauhaus case. If you're acting for the claimant, you'll want to push for that to be dealt with at the final hearing. If you're acting for the respondent, you will in all likelihood want to push for that to be done at the preliminary hearing. Now, on that note, I'm sure you're all gasping for some caffeine, so I will release you to go and grab a coffee and then join the rest of the talks later.
Thank you.